Madam Clerk, would you call the next case, please?
Lauren Justice et al. Versus Thomas Hanaway et al.
For the appellant? Yes.
Good morning, and may it please the court. Lynn Guerrero for the appellant. I wish to reserve 5 minutes for rebuttal, please, if I could.
Thank you. You may proceed.
This appeal rests on whether an expert witness may be court-appointed by implication and enjoy quasi-judicial immunity by virtue of such an implied appointment. The answer is no, particularly given this court, in its 2019 opinion in the underlying case, Nelson versus Justice, declared Appellee was engaged by Kim Nelson, who was a party to the litigation, rather than a court-appointed expert.
Was this court-appointed expert appointed by implication? Or did the order direct the party to choose a court-appointed expert?
Neither. The order that we're talking about here is a December 2015 order that removed Dr. Nancy Ellen Brown from her court-appointed duties, which she was appointed in September of 2014, and said, Ms. Nelson, you choose now.
Okay, well.
So really, neither by implication nor by direct appointment was the appellee appointed here. Appellee was just an expert, essentially, that Ms. Nelson chose to conduct family therapy for the family.
That was then according to the court order, though, wasn't it?
According to the court order, the judge, Judge Ash, in the underlying case, said through his order, you pick Ms. Nelson. Not court-appointed. Dr. Hanaway never received the order, never received any communication whatsoever from the trial court, never received any scope of work, any timeline for his so-called court-appointed work, nothing. Also, Dr. Hanaway abruptly quit providing family therapy for the family, never asked the court to be relieved of any duties because he didn't have any duties of the court. He was not appointed. Appellee moved for summary judgment in the trial court here and argued that he was immune from suit for his malpractice because he was court-appointed in the underlying case. And Appellee relied solely upon his own affidavit filed in the record in which he claimed he was appointed by the court. Appellee testified he did not receive any order, like I said, or any other communication from a judge or a court that he was court-appointed in the underlying case. Although he had decades of experience, he testified to, of court-appointed work where he would generally receive an order from the court or receive communication from the court about his appointment, including scope, timeline, things of that nature. And like I said, when he abruptly quit his treatment of the family, he didn't apply or seek an order for him for his relief from his duty because he had no duty to the court.
Ms. Guerrero, did your client object at any time to the use of Dr. Hanaway as the family therapist?
Yes, he objected to him as a family therapist, and he also objected to Dr. Hanaway testifying voluntarily in the underlying trial. And that's cited in the brief as well.
What is the evidence that he objected to the transition from Brown to Dr. Hanaway?
I think in the order, and I'll get to the order here in a second as to why it's inappropriate to rely on the order here. However, the order specifies that Ms. Nelson did not want Dr. Brown to be the court-appointed expert anymore, didn't want an expert, didn't want the family therapy to move on. I think the order essentially says, Mr. Justice did, but as the trial court, we're going to remove Dr. Brown and Ms. Nelson. You can choose a therapist. That's under your discretion. And Appellee here even argued that it was Ms. Nelson's sole discretion to pick a family therapist. In the trial court, Appellee argued. That's exactly what Appellee argued. Further, Appellee filed a supplemental brief with attachments 2 days before the scheduled hearing and after the appellant responded to the motion for summary judgment under Rule 56, and attached the order we're talking about, removing Dr. Brown and telling Ms. Nelson, hey, you pick the family therapist, basically the trial judge basically removing himself from that realm, and gave Ms. Nelson sole authority to choose another therapist. When Appellee filed this 2 days before the summary judgment hearing, this is the first time the order had been filed in the trial court here. And the first time appellant was made aware that the appellee would rely on this order to support his motion for summary judgment. Now that's in violation of Rule 56. The appellant has to have, the non-movement here has to have an opportunity to respond. 2 days before the hearing, that totally wipes out the safeguards of Rule 56 and is inappropriate. And even if this court disagrees with its own 2019 opinion in Nelson versus Justice and holds that the appellee was court appointed and that quasi-judicial immunity is afforded to him, quasi-judicial immunity isn't limitless. And I cited this in my brief on pages 23 to 25, I believe. Acts considered far outside judicial function or in any way outside the judicial function or in any way related to the judicial function are not immune. Dr. Hanaway used some extremely vulgar language during family therapy in reference to the family. He used sexual and degrading language to describe Ms. Nelson, degrading language to describe the minor child in the situation. Appellee made several comments to appellant about his sexual attraction for Ms. Nelson, her appearance, and in one case about how he was sexually attracted to Ms. Nelson but not sexually attracted to Mr. Justice.
Counsel, wouldn't that be an issue that has gone past of what we're to consider in this matter?
No, and here's why. Even if this court gets past the fact that Dr. Hanaway was not court appointed, that this court said he was engaged by Ms. Nelson in a published opinion in 2019 and gets past the Rule 56 violations, he's still not immune. And that's the point that I'm making here. He's still not immune. He still doesn't have quasi-judicial immunity because these situations, these comments, this malpractice is so far outside the realm of any quasi-judicial function that he shouldn't be afforded immunity, even if you get past the 3 or 4 steps that you must get past to get there.
Wouldn't that be a factual issue that has to be considered by the trial court regarding his activities as a therapist?
Right. It does, and
so that would not be something that we would take up, would it?
Well, the appellant raised this in his additional material facts to show that Dr. Hanaway, no matter which way you cut it, is not judicially immune. Raised these issues in his additional material facts that the trial court never considered. So yes, that is those are factual issues that the trial court would consider and that were brought to the trial court. However, they weren't considered. The trial court here solely relied to grant summary judgment to the appellee, solely relied on the order that removes Dr. Brown and gives Ms. Nelson sole authority to pick a family therapist. which was filed 2 days before the hearing was set. I think the hearing was ultimately rescheduled due to COVID-19, but the fact remains still that the hearing was set. This was filed 2 days before the hearing. The appellant did not know that the appellee was going to rely on this order, because for years, the appellee had only relied on his own affidavit, and the appellant and his counsel, me, deposed the appellee based on his affidavit, based on what he was relying on for summary judgment. And now it's all changed 2 days before the scheduled hearing. That's not proper under Rule 56. And this court has the authority to look, under Tennessee law, look at the record and say Rule 56 wasn't followed, even if the trial court didn't go there, which he didn't, but relied solely upon the order that was filed late, and not proper under Rule 56. So we ask that the court reverse the trial court here and appoint a different trial court on remand as well. Thank you.
Thank you. You have your rebuttal time. Yes, sir.
Good morning, and may it please the court, Joshua Cumbie on behalf of the appellee, Dr. Thomas Hanaway. The trial court's order granting Dr. Hanaway's motion for summary judgment should be affirmed because all of the undisputed facts show that he was a court-appointed family therapist in the juvenile court under the juvenile court's December 2015 order. There is no dispute that the juvenile court ordered Kim Nelson to choose a replacement for the existing court-appointed therapist, Dr. Brown, in December of 2015. There is also no dispute that Ms. Nelson chose Dr. Hanaway. So there really can be no dispute that Dr. Hanaway is a court-appointed therapist who's entitled to quasi-judicial immunity. Now, counsel's correct that the February 2016 order that memorialized the December 2015 oral order for Kim Nelson to replace Dr. Brown with a therapist of her choosing was not formally introduced into the record until it was attached to a supplemental brief filed on summary judgment shortly before the hearing. However, there is nothing new in that February 16 order that the trial court relied on that Mr. Justice wasn't aware of well in advance. Mr. Justice, in his response to Dr. Hanaway's statement of undisputed material facts, admitted all of the facts that I just recited to you that the trial court also relied on in its order granting summary judgment. That is, that the juvenile court ordered Kim Nelson to choose a replacement for Dr. Brown and that she chose Dr. Hanaway. Thus, Dr. Hanaway was a court-appointed therapist. There was nothing new about those facts. So the fact that the order entered the record later on, and the reason for that was because it was a juvenile court order, it was under seal and had to be obtained. It took some time to get hold of. Again, we're talking about events that happened during the pandemic in the course of this case. But there was nothing new about these facts. And the trial court quite properly relied on that order because, again, all it did was memorialize what the juvenile court had ordered in December of 2015. Kim Nelson, you're to choose a new court-appointed therapist. I'm replacing Dr. Brown. Find somebody else. At that hearing in December 2015, counsel for Ms. Nelson offered to give the court Dr. Hanaway's name. Court didn't want to hear it. Court said, I don't care who it is. Ms. Nelson chooses. She has the authority to find somebody else to take Dr. Brown's place. So all of those facts were already in the record. Justice had already admitted all of those facts in his response to Dr. Hanaway's statement of undisputed material facts. The February 6, 2016 order merely memorialized what had already happened. And in April of 2021, before the supplemental brief was filed and the February 2016 order was attached to it, Justice stipulated to the authenticity and the admissibility of the February 2016 order into the record. So the February 2016 order in Rule 56, it's a complete canard. It has nothing to do with what has actually been established in this case by the admissions of Justice himself. Now, Justice makes several other arguments in his brief about why Dr. Hanaway couldn't be a court-appointed authority. He says the juvenile court never specifically named him, either at the hearing in December 2015 or in the following order in 2016. But there's no legal requirement that the court do so. There's also arguments made that somehow somehow Dr. Hanaway was not made aware of the juvenile court's order or didn't understand the assignment, but that's not true, and we know it's not. On page 213 of the record, we have the letter from Justice's office sending the juvenile court's December 2015 order to Dr. Hanaway, in addition to Dr. Brown's contact information, so that he could reach out to her to smooth the transition from Dr. Brown to Dr. Hanaway. So, notwithstanding his testimony, which cannot change the facts in this case, Loring Justice sent the juvenile court's December 2015 order to Dr. Hanaway. So Dr. Hanaway knew that he had been chosen by the court because he had been picked by Kim Nelson under the court's December 2015 order. So we understand, Dr. Hanaway did understand his assignment. He did function as a court-appointed therapist. He testified at trial. And it's only because his testimony at trial was not liked by Loring Justice that we're here today on this suit. That's the only reason that this happened. At the time that the juvenile court in December 2015 ordered Kim Nelson to find a new family therapist, there was no objection from Loring Justice. There was no objection from Loring Justice when he sent a copy of the December 2015 order to Dr. Hanaway, who he knew Ms. Nelson had chosen to replace Dr. Brown. And there were objections at trial, but those aren't really material here because those objections were to his testimony, not to his appointment as a family therapist in the underlying juvenile case in Roane County. All of the remaining arguments about the derogatory comments and Rule 706 were waived because they weren't raised in the trial court. And contrary to Ms. Guerrero's argument, Justice did not raise any of those issues in response to the motion for summary judgment. Justice did not file a brief in response to Dr. Hanaway's motion for summary judgment, and neither his response to Dr. Hanaway's statement of undisputed material facts, nor his statement of additional material facts, nor his declaration raise any issue about any alleged derogatory comments. So the only derogatory comments in this case are allegations from the complaint, but importantly, the trial court didn't grant a motion to dismiss, it granted a motion for summary judgment. And Justice never marshaled any evidence whatsoever that Dr. Hanaway had ever said or done anything that would strip him of quasi-judicial immunity. Instead, they make these formalistic arguments about why he should be stripped because he wasn't named in the order or the juvenile court didn't specifically identify him from the bench and these kinds of things. The derogatory comments never got past the complaint. That's the only place that you'll find them. And you certainly can't use that to create a disputed issue of fact to preclude summary judgment. They didn't do that in this case, so summary judgment is appropriate. Unless you all have any questions.
I hear none.
Dr. Hanaway respectfully requests that the trial court's order granting his motion for summary judgment be affirmed.
Thank you, sir. Yes, ma'am, your rebuttal.
Here, in summary judgment, the notion Appellee was court-appointed in the underlying case is disputed, and Appellant presented evidence to dispute it. Appellant's declaration swearing no other professional was appointed to conduct family therapy in the underlying case. Appellee's own testimony, the only communication he received from anyone affiliated with the case at the outset was from Nelson's attorney requesting he, quote-unquote, help out. Appellee never received any communication from the court appointing him to conduct therapy and or describing the scope of work he was to do within a court appointment. Appellee also, during his deposition, was questioned regarding the family therapist, Dr. Torr, chosen by Nelson in the same manner she chose the appellee after Appellee abruptly quit his treatment. Appellee was informed, which this court opinion in Nelson versus Justice confirms the underlying trial court instructed Dr. Tor, that he was not court appointed. This is more than enough evidence to allow a jury to decide whether the appellee was a court appointed or not. Appellee's counsel even argued at hearing that the choice of therapist was solely left to Ms. Nelson. Argued here that the choice of therapist was solely left to Ms. Nelson, not the court. The trial court's order here, granting summary judgment, is based on insinuation and implication. The trial court's order simply states, it is reasonable to believe Dr. Hanaway would step into the shoes of Dr. Brown, who we all know was actually court appointed. It is not reasonable to believe that the trial judge in the underlying matter would appoint expert witness by such vague language. The trial court in the underlying case knew how to appoint a witness or appoint an expert. He did in September of 2014 when he appointed Dr. Brown. Did not do so with Dr. Hanaway. The test for genuine issue to be tried is whether a reasonable jury could legitimately resolve the fact in favor of one side or the other. Here, the answer is yes. Even if it were reasonable to assume, as the trial court did here, that the underlying trial court wished for appellee to take on a court appointment, and it is not given the evidence to the contrary, it is not unreasonable to conclude the opposite, that the underlying trial court did not appoint the appellee, given the circumstances that are present here. The specific evidence presented by the appellant and appellee's own words from his testimony, from his deposition, to dispute the notion that he was court appointed raises doubt, at the very least, which in turn creates a genuine issue for the jury to decide. And I just want to reiterate, appellee did not satisfy the requirements of Rule 56 here. Even though the order was years old from the underlying case, the appellant still was not put on notice under Rule 56 that the appellee was relying on that order. Just was not. And to respond briefly to the letter that the appellee's counsel referenced, the letter from former counsel of the appellant to Dr. Hanaway. Yes, Dr. Hanaway was sent a letter about a transition from Dr. Brown to Dr. Hanaway. Of course there was a transition from Dr. Brown to Dr. Hanaway. Does that letter say that you're now the court-appointed therapist? No. Does the letter, did Mr. Rickman, who was appellant's former counsel, have that authority to appoint a witness? No, and neither did Kim Nelson. The only communication Dr. Hanaway got at the outset was Kim Nelson's attorneys called him and asked if he could help out. That does not create an appointment. Ms. Nelson, neither Ms. Nelson nor her attorneys, nor Mr. Rickman, former counsel for Mr. Justice, had authority. The only person, the only entity that had the authority to create a court appointment was the trial court, and we just don't have that here. So the logic here is simple. The court should follow the logic rather than allow jurisprudence that hurts the court system, and we ask the court to reverse and appoint a new trial judge on remand. Thank you.
Thank you. I want to thank both of the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you both, and you may be excused.